Welcome, everybody. Appreciate you joining us today here for this webinar. I'm Jerrod Mills here at TrialQuest, with me as well as Kevin Jarrard. And we're going to spend a little time today talking about kind of looking at trying cases in the coming year, some of the challenges that we see and things that we're dealing with, and some ways to prepare and put together your presentations as we look forward and kind of, this, ongoing year for 2026. My background here at TrialQuest is I'm in charge of a lot of our case strategy, graphics, presentation development. I've been doing this a little over 22 years now, previously with Trial Exhibits, which became TrialQuest. And Kevin, you can talk a little bit about your background as well. I know we've worked together for a long time here.
Yeah, I've been with TrialQuest, Trial Exhibits, for about 15, 16 years now or so. Jerrod and I have been together for quite some time. The J's tend to lend together and work well together too. But
Yeah,
my background
joke that
is
we don't hire people with J names. So.
that's right, make it as complicated as possible. But my background is more of a trial technology role. So I was a trial technician for some years, working about 500 or so cases throughout the nation, working with attorneys on different types of litigation, building graphics, assisting with some of the medical illustrations and animation department now, and working specifically with U.S. Legal TrialQuest on all their cases throughout.
Great. Well, I'm going to share my screen. As much as we probably want to stare at each other's faces as with these webinars, it's probably a little more exciting to see some slides. So give me just one second. I'm going to go ahead and share that. And hopefully can you see that, Kevin? That's up there.
Good to go.
Great. All right. So as we kind of look forward, obviously we've had a lot of changes as we've gone through the last 5-8 years in trying cases. We work on about 800 to 900 cases a year as a company at different stages of litigation, all the way, with a lot of that being going into the courtroom and helping attorneys, develop and present their cases. So what we want to kind of talk a little bit about is kind of some of those things that we're seeing, some of the trends. What are some things that we can deal with, as we kind of look at those elements? There's a lot of challenges as we look at headwinds with jurors and judges, time constraints, overloaded court systems. So it's really important as we look going forward of how best to prepare for those. Obviously a lot of the talk and hype and kind of things that we look at are the AI tools that are out there. There's a lot of great ones that are being developed. Some really good ones that can help you in your preparation. Depo summaries, record summaries, those types of things. And ultimately, we're not going to spend a lot of time on that. But what I think is important about those tools is it really sets the table to have more time to spend on developing your presentations. And so I think utilizing, those types of tools to really kind of get your case through discovery and preparing for depositions and whatnot is a key part of this. We're going to focus a little bit more on the actual kind of putting your presentation together, some of the tools that are out there, and some of the times when it's best to use those. As we kind of look at the litigation timeline, one of the big things we always talk about so often is we focus on juries, right? Our name is trial. We talk about the courtroom, presenting to juries. One of the biggest elements we kind of look at here is don't miss the opportunities to develop your presentations, your demonstratives, and deliver your message to judges, arbitration panels, mediations, helping your client in a depo, explain these complex things. Getting a good ruling can really set the course of the case as much as presenting in the courtroom. So, we really encourage our clients to, not that you have to call us and hire us immediately as you get a case in, but you need to be thinking about the framework of your case, your message. We're going to do different types of presentations based on the audience, but our judges need context just as much as jurors. They understand the law. They might be able to read a contract a certain way, but they really need to understand the methodology, what goes on a job site, how construction processes are going to work and sequence. So don't miss those opportunities to advocate for your client along that timeline.
And there's other portions of it too throughout the actual litigation that you can focus and that we can actually prepare with you, as far as briefings, hyperlinking briefings. If you have hundreds of exhibits that the judge may need access to, not necessarily has to have access to, but want to be able to go back and forth from your briefing itself to the exhibit that you're referencing at their own leisure, we can hyperlink all those items and make it a little bit easier for the judge, the mediators, whomever it may be, to read through that briefing and go back and forth and actually see what you're discussing and really comprehend exactly what it is that you're trying to display within that briefing.
Yeah, and I think that really hits on the overall message as we look forward to trying cases in 2026 is you really have to deliver more context. You got to build credibility with your audiences. You can't just win cases with credentials. You know, your expert might be the best expert in the world, but it's really how do they teach to the jury? They want to understand. So these types of elements that we use even pre-trial, you know, hyperlinking briefs, creating demonstratives even for expert reports to make that complex process stand out a little bit and make it easier to digest, I think is really, you know, one of the biggest things we have to work on in 2026 moving forward. And so as we, you know, we talked a little bit about pretrial, you know, obviously we're always curious about how do we work with jurors? How do we deal with, you know, the biases and things that we're going to have in our jury pool? We always need to be thinking about delivering your message along the way, you know, as you're doing your depositions, as your experts are putting the reports together, you know, an affidavit, you have to think about where you're going to deliver that message to, and not just, you know, so often we're really dealing with these topics a week, 2 weeks before trial, trying to create an opening statement. We need to be thinking about this along the way as you're building your case. And so, you know, this is kind of a broad brush view. Every venue is going to be a little different, you know, the demographics in the jury pool, but kind of, you know, some of the things we see trends that we need to think about as we're putting presentations together is with our jurors, you know, in today's world, we really have jurors that are very skeptical that, you know, the legal system actually works for people. A lot of them, as we see through the research, you know, and studies are, you know, the laws are very outdated. So jurors tend to sometimes kind of view their own justice. You know, they're trying to kind of come up with their own way to give a fair answer. Obviously, our society as a whole is very hindsight oriented. They don't really tend to look at things in the process. We look at headlines, we look at the final outcome and then judge it. But a lot of our cases are tried in more of a prospective view, kind of the process. So we have to deal with that when we're trying to teach a process. We have to go over the top with our education there. We have a very safety-oriented society. You know, we've kind of grown up with helicopter parenting and doing things that are as safe as possible, you know, elimination of risk. That can create a lot of issues in the type of case that you may have if you're dealing with safety issues, warning labels. You know, there's things that we have to take into account when we're putting those together. And then lastly, you know, no matter which side a juror is on, you know, a defense or plaintiff-oriented juror, all of them really want to boil down to a simple answer. They want to know why they're there, and they really want to make it as clear as possible so they can make a good decision. They're really trying to make the best decision they can. And so, you know, many times the other side may have a more simple case or a more simple explanation. We have to look at our cases and do the best that we can to do the same and kind of boil that down. And so there's ways to kind of work through that, you know, doing jury research, developing our messaging so we can reach all of the jurors, even ones that may come in that aren't, you know, leaning our way in the case from the beginning.
And blending into that, the trial environment itself is different than it used to be. I mean, look at pre-COVID courtrooms, look at pre-COVID rulings, look at all of these things that changed in a very, very brief period of time. The tighter court schedules, the docket system alone now has changed throughout the country. We used to have all of these special set cases that would go and we knew when we were in court. Now we may not know until the day of when we need to be prepared, have our experts in the courthouse, have all of our technology in the courthouse, and have everything ready to go. Going straight into your technology expectations with that too. The judge wants you ready. The judge wants you in the courthouse on Monday because they gave you 2 hours to show up to come in and get your presentation in front of the court. Get your presentation in front of the juror and get everything tried. Get the case done so they can move to the next trial. This environment is rapidly different. We have to move at a faster pace. We have to be prepared and we have to have everything ready because the court expects it.
Yeah, I know it's crazy when we look at trials now. I mean, I think the other day I had a call with a client and their pretrial conference or docket sounding had over 100 people attending. You know, so it's like nobody really knew where they were on the docket that was coming up in about a week and a half. And it's just kind of crazy, you know, the world we live in now where judges are trying to put as many cases forward as possible, you know, clear backlogs of different court systems. So We find it, and I've had more cases lately where we had time constraints, right? Where they're basically, we have 2 weeks to try this, and we're running out of time near the end of the second week, and the defense is getting pushed to rush through and finish on time. And then I've had time trials a lot lately in some of our cases where we had 40 hours total to present. So, taking all those into account, we really have to kind of prepare in a way to go quicker, be more efficient, avoid delays. And it's not just, do we have a projector or a TV? It's like, what do we do if we have a technical issue? So, it's definitely a little more challenging as we look towards those preparations to do that. And we're going to transition a little bit and talk about demonstratives in general, and then we'll go through some different samples. But, I always bring this up because it's something that happens often in a case meeting. We're sitting down with a client, we're kind of going through some of the issues in the case. And many times the client may say something to the effect, this case isn't really a graphical case. I just need to show the records. I need to show these photographs, which is very true. A lot of cases, we do need to show the jurors the documents, the evidence. They want to see it. They want to see it's real. They want it to be authenticated, that someone actually wrote that email. So showing those documents is really important. But I think there's a little mixing of terms here. When people say, I don't need graphics, they're thinking, I don't need a 3D animation, an interactive, a medical exhibit. But what we need to be thinking as a whole view of the case is, how do I deliver the roadmap? How do I make my narrative or storyline resonate with the juror? And a lot of times what that is taking those documents, showing them, but putting them in context. And so timelines and charts that give that kind of summary version, that context that the juries can understand it and reference it as they go to deliberate, is just as important. So we need to be thinking about our opening, thinking about our experts and how they're going to talk, our clients. Likability of our witnesses is super important. So we need to help them have credibility with the jury. And so, many times when we say we don't need graphics, in the sense, yes, you probably don't need a 3D animation of this accident, but you do need to make your documents fit into the storyline. So, don't write off the ability to do some type of opening or a simple timeline even. A lot of them don't have to be overly complex or overly done. They can be very small and kind of just informational even. But you need to be thinking about giving clarity to those documents. You flash up 100 records in a row. They might be all great records. But if that jury doesn't really understand how it fits into the motive of the case, the theme of the case, you're going to have issues there for them to kind of retain that information and then use it to deliberate. And I think it's important. Go ahead, Kevin.
No, the newest tools aren't always the most effective, to your point. I mean, if you have a timeline, you have a very simple chronology, you have a billboard pretty much of what your case is about because you've already built it, that can save it from the jury the entire time with just a trial board. It's an old school method, as we like to call it, but it's also a very effective method that timelines, charts, all of your chronologies can actually be built in and keep it in front of the jury the entire time.
Yeah, and I think that's super important to think about, as we talk today about all these tools and, VR stuff and 3D modeling and all these things we can do. It doesn't always mean we need to go to that level. There's a lot of more simplistic things that might be able to deliver that message.
Effectively. Delivering the message effectively. Leaving it in front of the jury so they can actually have that clear message, whether it's a PowerPoint, so per slide, whether it's a trial board, like we mentioned, using those timelines, or even if it's a simple call out of a document that you plan to use over and over again, have it on a board, have it on a PowerPoint presentation, have your trial tech ready to use that over and over again to build that hierarchy so the jury can establish this theme that you have, and they can actually put everything together from day one and make it a callback all the way to day 5, day 15, day 30, whatever it may be. They may need something simple like a 3D model. While I say simple, it's a little bit more complex to develop, but it is a physical thing that they may be able to hold in their hands to understand what this case is about. In animation, when it's not appropriate to have a 3D model, so you can reference it throughout the case and put them in place of the actual problems, the actual issues of the trial. All of these need to match your attorney's voice, though. It needs to match your theme. It needs to match how you plan to present these items, whether it may be an interactive to get your witness a little bit more responsibility on the stand, to give them a little bit more actionable items when they're actually sitting there in front of the jury, getting them off of the stand, even whether it may be a touchscreen monitor, a touchscreen television, to go through some of the exhibits you're showing, or make it as simple as just a map, a nice contextual map, a nice contextual way to go through it, and it gives the jury a good starting point, a good bookend, a good bookmark throughout the case, that their notes are going to match exactly what the exhibit showed.
Yeah, and I think that's really important. I think, when we work with clients, a lot of them, they're developing presentations, they're putting PowerPoints together, which is great. And I think that first bullet point really it hits home is, making sure that your slide, if you have multiple slides, have a clear defined message to them. Many times it's overwhelming amount of data. So I really encourage, as you're putting your outlines together, to be thinking about that and how does it connect, those multiple slides as we walk through those. I think as we look towards demonstratives, one of the first things we all think about is timelines, right? Like our brain wants to put information together in a coherent fashion. They want a chronology. We all think that way. We retain the information better when we have kind of that storyline that flows. We want things to be kind of in order. When did this happen? What happened next? How did we respond to it? It kind of helps deliver that theme and the message along with the data. Why is this happening? Why did this occur? Which can be a big part of making your case resonate with the jury. There's a lot of different ways to do timelines. We always look at the data first, and then what's the goal of that exhibit? And then we're going to formulate the best layout to match that. And again, they're not always super complex, but we do want to always make sure we're using the layout and spacing to guide the message. So it all goes together and it's not just kind of data put on a slide.
And it's not just the layout too, it's the interactivity with it. So you may have a standard static timeline that goes end to end, a nice linear view. You may need to have something a bit more complex, a bit more busy, we'll say, like a calendar graphic. A standard graphic is helpful. You can show all of the amount of visits you had, all of the different check marks, whatever it may be throughout the case, on one calendar graphic, or we can go one step further and make it more of an interactive calendar graphic. So every single orange square you see here, we can link a document. We can give you a bit more of an action to go back and forth and show the jury exactly what you have, or just show this one cover page to show the amount of communication, the amount of time it took, the amount of visits they may have had to a doctor, whatever it may be, and just display it as a good splash screen in front of the jury.
Yeah. Yeah, good example there. And I think that's kind of where, when we look at, and when we think timelines, I think most people immediately go to, the data points, a chronology, kind of the traditional look. But we also need to think about the other tools that are available as kind of developing, the process timelines, kind of teaching tools. So this was a case where we had a very rare condition with hypoplasia of the optic nerve. Before we ever get into the issues in the case, we have to really look at, can the jury understand the normal development of that baby through the gestational weeks? So, using a timeline that kind of goes through those weeks, what's normal development versus abnormal, kind of sets the foundation as we get into the actual opinions of the experts and the treatment in a case or lack of treatment, whatever the case is about. You got to think about utilizing these charts and timelines also as your teaching tool. Again, kind of development, how does the process happen? What are the steps in order to show that things are being handled or not handled, depending on the type of case you have. And again, it's not just limited to particular types of cases. This was a FINRAR arbitration. So you're dealing with a lot of financials. You have a very educated audience with the arbitration panel. And obviously you look at a lot of spreadsheets and data points, but sometimes you got to step back and it's the simple version. Again, we want that simple answer. How many times were they outside of the threshold? So again, it's not about individual data points, it's the impression. So we look at those, can we take that data and make it more visual as one of the tools? And again, it can be static, it can be interactive, it can be a PowerPoint, link in records, all those types of things can happen, but it delivers the context that this was someone that was constantly above the threshold. And so it goes in, we're going to still look at the documents, we're going to still look at the spreadsheets and that type of evidence. But taking this into kind of that opening and closing graphic really helps deliver that message in a little bit easier way.
But what's an ineffective demonstrative? I mean, we can give them all of this data, we can add all of these data points, but overloading data, overloading text on a graphic, on a slide, whatever it may be, is just going to confuse the jury. Also, keeping it within the theme, keeping it within the strategy, the presentation ideas, everything you may have is just as appropriate and just as required for your graphics as calling for an animation, whatever it may be. The styles all have to match. Your PowerPoint has to be consistent. All of these things are important, but the most important part of all of it is actually getting the process started earlier. Making sure you meet with the right people to get everything done correctly rather than rushing to the finish line the day before court or the day before a due date to a court and getting everything done. Excuse me. You can go to the next one.
Yeah, I think that second bullet point is probably one of the things that I like clients to think about is many times we get excited about different points in a case, right? And so this means a lot, this means a lot, this means a lot, but we never connect them together. And so, having great points, but that don't really flow together, don't connect. A lot of times that's not going to resonate with the jury. They're not going to remember it quite as strongly as we would like them to. So, you have to think about how those good points kind of come together, and how they go to the overall theme in the case. And giving too many good points kind of weakens the great ones, right? We really want to focus in on 3 to 5 great things and how that's all supported and pull things in support of that versus having 15 to 20 good points that kind of get lost and kind of a little bit overwhelms the jury as we walk through that as we go. One of the things as we look towards trying cases going forward and some of the things that we've been doing and seeing a lot is a lot of our cases we're going to have to explain very complex things, right? It's a pretty big mental lift for the jury to understand, even our judges. And so, as we talk about the different tools with newer animation styles and interactivity and document callouts and all these things we can do, we really need to think about how are we learning? How do we learn today? And I think my equation is, what do I do in my daily life if I need to fix something? I go to YouTube and I Google it or I YouTube it, and up comes a video that's 5-6 minutes long. Someone showing me how it works, how they fixed it, what I should use, what are the alternatives? Don't use this tool because I've tried it, it doesn't work well. That's how we're kind of receiving information. And when I say YouTube, I don't mean you have to have a video or an animation to do everything. It can be a series of photos and documents, but we need to kind of connect it like a tutorial where we can walk through. And I think that's also why a lot of our clients tend to use PowerPoint. We use it as a final product to deliver those messages. A lot of times it's easy for our clients to work with. We might be pulling together a lot of different graphics and images and animations into that. But we need to think in that kind of tutorial format so we can kind of give that information to the jury and make it as simple as we can. This was a recent case dealing with a cancer that developed and going through the treatment process. So we had a lot of complex topics. What are the DNA strands? How does the cancer develop? How does it replicate? And those types of things. And so, just even getting the jury to kind of understand what's going on with this replication, how these cells are developing. And I'll kind of skip through this. So it's a pretty long presentation overall, but there's multiple steps here where that cancer is going to replicate a strand. And then, in this case, we were defending a doctor who treated this. And so we had to lay the foundation of what is it? How do we deal with it? What's the medication? So I'm going to kind of quickly breeze through these. So we're using a mix of a lot of tools, very simple two-dimensional graphics. We have some 3D elements. We have some photographs. We have some tutorials on the medicine itself. This was where the cancer was growing and how it kind of the doubling rate happens. And then after that, we get into what treatment was actually done. And it's a BEP was the treatment that was provided. And so what we needed then to even break it down further is we start walking through how each phase, the B, E, and P, all treat the cancer. How does it prevent the replication of the DNA strands? And so, again, this is a long form presentation. We're kind of shortening it down a little bit here. But, the key was that this person needed all 3 elements of treatment. Obviously, there are risks with the different types of treatment, but obviously you're making the most reasonable judgment in how you're going to treat this patient to give them the best outcome. So we had to teach that element of how all three of these things come together to do the best treatment for them. Again, a very complex task, a lot of heavy lifting by our client as well as our expert to be able to go through these different phases. And so this was meant to be kind of a longer, multiple slides and kind of walking through that. And then we summarize it with some more simplistic graphics of, you need all three elements to be able to prevent, the replication of this. So we get the best outcome. So, we really need to start thinking about if it's a construction case or IP and how, a product is used or, the utility of it, all the way through medicine and products, all these types of cases, there's usually a point where we might get some complexity. We need to be thinking in a tutorial form. We need to be teaching, not telling our jury. And that's where we're going to get that credibility to have those jurors go into the deliberation room and kind of, argue our points and try to move those other jurors. And as we kind of look at the different tools, one of the next ones we're going to talk a little bit about is using animation, right? And so there's a lot of different ways to animate. I always, again, no matter what type of demonstrative or tool you're going to use, we always want to ask, what's the outcome? What are we trying to get across to our audience? And so in this case, we had a speed differential issue, posted speed limit versus the speed of one of the vehicles. And so the goal was to show the difference in that speed. So, again, we can use a two-dimensional overhead view using Google Earth images, but then we can also use point of view. And again, it's not just one singular animation, it's doing a split screen, which helps deliver the message about, but for the speeding, this accident doesn't occur. You can look at that to use it in different ways to kind of deliver that message as well. Same thing with animation. Many times when we think about it, it's an accident, it's a product, it's something, medical. But other times we might look at, here's an injury that occurred. Well, how did it occur and how does that change the future care and treatment that's needed? So again, utilizing the tool of animation, we're going to take those x-rays and op reports and turn them into something that is a little bit more understandable about the severity of an injury. This was a gentleman that had an angle grinder that broke off and went through his forearm. Obviously needed some pretty heavy future care and treatment. And so this animation exhibit was really just to kind of set the foundation that this person had a lot of future care and treatment needs. So it wasn't just about the actual failure or lack of failure of a product. We're also trying to fit into the narrative of kind of what's the course going forward for this person after this injury. So using 3D modeling, three-dimensional views, animation can kind of help paint that full picture when we look at that.
And it shows the importance of angles too. It gives you a good idea of one view may not look too severe, the other view is very severe.
Yeah, very good point. Good point.
Broad picture too. So this was a project. And when I use the word project and I sigh, it's for a reason. Every single yellow dot on this map, one of our technicians, one of our graphics teams, one of our employees had to travel to it. There were a ton of dots. There were a ton of places we had to visit and take individual photographs. So this was Case New Holland, CNH as we call it. They had a sign failure. All of their signs were back sprayed. The sun bleached them. They had some failure throughout it. This wasn't just a singular event. This was every single location that this sign developer and production company created and sent out that these individual franchisees had to purchase directly from them and then had the poor result that you see here. All of these images, I think it was 7 or 8 images per site were brought into one individual player that was easy to use, easy to recognize every single image that we took and quickly go to them during this. Was it a mediation or arbitration? I can't remember, Jerrod. Do you remember off the top of your head?
Multiple things. We had from hearings, bench trial, and then towards the eventual trial. So, and the challenge is, as Kevin was saying, is that this was a place that had 741 dealerships throughout North America. We ended up with about 15,000 files of photographs, and we needed a way to organize it so it was easy to use. Again, we had all these photos, but you need to give them context. Is where was it at? These weren't all places that were in Florida or Texas with heavier sun. They were the same type of failure patterns in other areas. And so this is where interactivity really comes together. You're looking at 2 or 3 different things coming in. You're summarizing lots of data. You have geographical elements, you have timelines. that come together. And so, we're not going to be able to go through and show every single one of these sites. But what you want to do is show the foundation that you have multiple sites at any time you can click on, go to, and then you can, in a summary form, show all of these different locations. So that's where we really see interactivity kind of coming together to manage a lot of this. It's word searchable, you have menus. It makes it very easy and dynamic to handle a lot of locations and data as well. And that kind of, when we look at a lot of our projects, it's what tool is best fitting. And so many times we're going to do an animation, other times we're going to do a 3D model, other times we're going to do something interactive. A lot of times we need to think about how we're going to deliver that information, and it's blending those styles together. So we might want to make an interactive of a 3D model. So we can do real-time rendering style, so it's like a video game. But a lot of times we end up using a menu system so you can control the data on the screen. Very important. So, it's easy to change the views. You don't get in a weird spot, kind of like on a video game style. If we have different experts, that's something to think about. If you have different experts, they're going to talk about different elements of a larger plant or process or construction. You can utilize an interactive to be able to control what that expert has on the screen. So there's no objections from the other side that, they're out of scope or talking about something that's not there underneath their kind of testimony. So, that's another area where blending the 3D elements as well as looking at interactivity together with menu systems really comes together well.
And going further into it, these images, all these LiDAR scans, all of these things that we have to rely on to get all of this data to create these interactive exhibits, these animations, whatever it may be, can be brought into more still images, to more 3D models, to items that we can actually put the jurors inside of it in a 3D scale so they can see completely all around and see exactly where they are. The right-hand side was just an image, was a photo taken of the dump truck itself, and we were able to bring in some of these scans and bring it to life a little bit more for the jurors to be placed inside the location itself. The back news flow, Jerrod, you know a lot more about this one than I do.
Yeah, it was just, again, just a process diagram where we wanted to go kind of frame by frame rather than a 3D animation. Some of the things to think about with animation versus stills is, one, sometimes when your video is playing, it goes by too quickly. You're trying to pause it all the time. You're trying to pace it so your witness can talk about it in the correct timing. So that's where stills in a sequence kind of might be a little more powerful depending on the message you're delivering. But part two is, another thing to think about is with 3D stills, you may not have enough information or expert testimony of opinion that can support an animation that plays and shows full motion. You might have to use stills because that's an area where you can kind of show a before and an after or a moment within a sequence. And it kind of keeps you out of some of those things that might be more objectionable if you showed motion and things that happen from A to Z with an animation. So that's some elements too, as you're thinking about tools and how you can present your cases, is using stills effectively. That could be one way to kind of handle that. If you don't have the testimony or data or support to be able to show kind of that frame by frame all the way through, you can kind of do it piece by piece in some of the stuff that you have support for. And then, another tool that we look at, it's, to us, it's kind of been around for a little while, but for a lot of our clients, it might be a tool they haven't used quite as often, is 3D printing. So 3D models, there's pros and cons to every type of demonstrative you use. We do a lot of, this is kind of like the trial boards of our animation and models, which is great because I think it's really important to look for mixed media opportunities, things that can be held or put in front of the jury, left up on an easel. 3D printing kind of fills that need as well. A lot of things we're going to do animation, interactive up on a 8-foot, 10-foot screen in front of the jury. But other times we may need size and scale. We may need something very specific to be a certain size to be accurate to that case. So that's where 3D modeling and printing comes in. It's a lot more cost effective than the hand modeling that we used to do 20 years ago, building out those scale models, which we still do those occasionally. But more so we're looking at kind of these 3D printed, being able to use scans and imagery, CAD files. We can take those and turn them into a model. So you see here, there's a baby's heart there on the left. You can see the size and scale versus a quarter. So it gives you kind of perspective when you're looking at the anatomy. Same thing with the baby you see on the right. You see kind of the printed model there in the white. that our animator was actually holding, and then it was the finished model, as you see there in the main image, printed, painted, sanded, and finished. So it's more trial ready. So
And
a
trial
lot of
ready
pros.
from an expert as well. Sorry to jump in, but trial ready from our medical team, from the medical illustrators and animators who are all certified, board certified, and they know exactly what they're doing. They build these items through the DICOMs themselves. They scale it up, they volumize it, they bring it in, they sand it, they then paint it to make it as accurate as possible for the jury to actually be able to see it.
Yeah.
Sorry, I didn't mean to interrupt you.
Yeah, no worries. Yeah, that just gives it some of that authenticity that you need for using it there in trial. And we don't have enough time to kind of go through every single tool, and hopefully we'll get back together soon and go through some more specifics. But in other areas that we look at is we talk about video depots and video editing and some of the things that Kevin will talk about in a moment for trial. We also need to think about surveillance video, right? Today we have more video and photographs taken than ever. We have store surveillance cameras, dashboard cameras, all these things kind of coming together. And the last thing you want to do is just play, a 4-hour video and you're scrolling around in a clunky player. You're trying to find the key point of where something happened within a store or an accident. Some things that we want to do is take that evidence, the video that's, evidence in the case, but give it context, right? So in this case, we had a plaintiff who was moving around the store. We wanted to show where was she, what cameras, what was going on in the store, any interactions that may have happened. So as the videos are playing, we actually had a timeline, and you could follow along. You can kind of see where they are in the store. So it's taking that evidence and giving it context. So, and this can be used in a lot of cases. Sometimes things are happening just off the camera. So we want to be able to kind of show the floor plan. Where are they when they go off the camera, how that happens. So again, just some different things to think about utilizing the same video, but how do we make it make a little more sense for our audience, and using some of those demonstrative elements. And with that, Kevin, I'm going to give you the mouse control. So hopefully this goes smoothly. Let me see here. Let me give you control and I'll let you kind of take over as we kind of go into the last section here.
Perfect. Looks like I have it. So moving into displaying all of these great things we just discussed with you and using your case strategy, using all of the demonstratives that you spent time building, how are you going to show it in front of the jury? What is available to you in the courtrooms and outside the courtrooms to prepare and to actually display it, like I mentioned? There's new technology in all these courtrooms. Every courtroom is different. I've been in courtrooms in Charleston, South Carolina that all have 90-inch televisions in all of them, and that's perfect. The jury can see it. It's a huge courtroom. It's a beautiful setup. It's out of the way. It's in the view of every single person. No problem. Go to Talbotton, Georgia, where there's only one courtroom and there's 0 outlets in the entire courtroom, and you have to figure out what you're going to do to display these items. There's new technology in some of these courtrooms post-COVID as well. They have wireless systems that use the little clickers that you plug into your computer that you have to have a downloaded app and everything else to actually go through it. Or there's the true wireless systems where you have to go through the IP and go through their technology department and make sure everything's appropriate to do airdrop, etc., to display these items. Some may have the systems where the judge or the clerk have full control over what you're displaying, and before it even touches the juror's eyes, they have to take a look at it, authenticate it, get into the system, and then it's on the screen. There's plenty of options within the standard presentation things that you may see. There's other items that you may want to bring into courtrooms. Some may or may not have the fun document camera, Elmo, whatever you want to call it. Some of them may have this in there with you, but they make them so small now that you can put them inside your bag and bring it with you. That's a larger one, but there's so many things that you can have trial ready and in your kit and available for your toolbox, like we keep mentioning, and walking into the courtroom prepared. Adapters. If you have an Apple product, what type of adapter do you need? If you have a Mac, what does it need? If you have the Microsoft Surface, what type of adapter do you need to plug into their system to use? What programs do you need to bring in with you? OnCue is a big one now for trial presentation. PowerPoint's still huge, as we've mentioned throughout it. Do you have DICOMs in your presentation? How are you going to show those radiology DICOMs? Who's going to control what? Who's going to sit where? What can the witness see? All of these newer technologies that are inside of the courtroom have to be reviewed and have to be tested prior to going to court. me see if I can click through this.
Yeah, I think that's, as I work with a lot of clients as they were preparing for trial, it's like, we're all using more technology internally than we ever have, right? Internal support staff, we're all on Zoom all the time. We're hooking up, laptops, we're working remote. So I think we get a little more confidence in our tech abilities, even though the legal industry, typically we're a little slower to move in tech. But I see a lot of challenges that come from that. As an example, I was helping a client recently, and it was a courthouse that got renovated, post-COVID, beautiful, big projector screens, monitors everywhere. Great. Our client shows up, everything's pre-wired. We helped them develop some presentation work. They were going to go hook in themselves. And of course, the court system's beautiful. They hook up, the resolution's not working, right? And so they had this great court system, no backup, right? And so now they're calling court IT. Court IT, unfortunately, we found out, and we were helping on it, is their scaler. They have a little switcher inside the stack of technology that had a fixed resolution. So when an actual user who had normal resolution on their laptop at the time went in, it blew everything too big. It was off the screen and whatnot. And unfortunately, there was like IT security settings where they couldn't actually get in and make those changes, even the IT at the courthouse. So, I say that, and as we get kind of this sense of technology is getting easier, we have more technology there. It becomes even more important for your staff or your vendor, whoever you may be working with, to be kind of more proactive. Because sometimes with these pre-wired courtrooms, which are great and convenient, we love them too, is you got to have backups. And, what are you going to do? Because that judge doesn't care, move on. If you have paper, hold it up. So, just things to be thinking about as we are moving through these kind of more technological courthouses, more tech savvy clients. Don't kind of get that false sense it's going to work because it's already installed in the courtroom.
And Jerrod, it looks like the PowerPoint is not on me.
Did I look at that?
Yeah.
Talk about technology. I must have. There you go.
Let's see here. Let's do it that way. Old school. With the technology, think about what the juror is going to see. So this is just a photo from, I think this was in Virginia, just a standard courtroom that you typically see. Old school projector screen built into the ceiling right in front of them. Fantastic. However, there is a seat and a computer directly in front of the screen. So if the clerk's sitting there, the jurors may not be able to actually see what's going to be displayed. Bring it back a little bit, we're able to bring in a television. So the jurors needed to see some DICOMs in this case, a few x-rays, and actually get a better view of what there's going to be displayed. So we brought in a nice television on some wheels that we can move back and forth depending upon what we need to do with it. We can bring it back to the middle of the courtroom too, get the witness off the stand, have them go through a few of the demonstratives and records to really bring everything together with the jurors. Or with depositions, if we actually need to show the deposition because the witness can't come for whatever reason, and display these exhibits at the same time, we're able to put all these things together to give the jurors just a very, very clear view no matter where they are in there. So just I'll let this play for a second to show what they actually saw.
Their findings. I would move the introduction of exhibit.
Displaying the deposition clips, bringing up text clips, bringing up, bringing up the actual exhibit itself, zooming in, highlights, we can have scrolling captions. All this can be done previously on the fly, whatever it may be, but also bring it back to Zoom witnesses. Zoom witnesses have the exact same thing. You need them to be there in the courtroom. You need them to engage with the jurors. Bringing in that technology for it is just as imperative, and making sure the view that the jurors have, that the court has as well, is like they're in the room with you. Go ahead, Jerrod. I think I interrupted you.
Yeah, and I think, as I pull back and kind of talk a little bit about, just general use of technology and jurors and their feedback is, traditionally, playing video depots, you're just playing the depot, right? And we want to make it as live as possible. So you want those documents, you want them zoomed in on, authenticating it, kind of getting credibility with the jury. But I've seen some of the opposite of, for a period of time post-COVID, early Zoom depots, clients were showing documents that aren't going to be in evidence, as discovery phase. And so I know a number of times recently helping clients where the depot's playing and a document came up, we had to basically redact or re-edit that depot to remove it. A lot of the new depot programs and platforms are kind of managing that much better. But as we, even today in 2026, we're playing depots that might've been taken, shortly after COVID. And we're dealing with, some of those things. So again, it's not just, okay, let's show the depot, let's show a document that's in evidence now. You also got to think about those elements of what might have happened in that depot that weren't going to become part of the evidence in the case, or an admitted exhibit. So, just some different things that, with presentation tools and utilizing those the best way.
Yeah, there's a learning curve for a while. Now there's a fixing curve. Now we're able to go back in and make sure that everything's appropriate the way we need it for the case itself.
Yeah.
Just click through. And the trial technicians are the ones responsible for this. There's no other way to put it. They are the ones who are going to be in court with you. If you do hire a trial technician, hot seat operator as they're often known, they are the ones who are going to make sure your technology runs. They're the ones who are going to make sure that the technology is in the courtroom. It's set up. We work with the courts. We work with you to make sure we have the appropriate orders to get into the courtroom with the appropriate technology. And we're the ones to make sure that you can focus on being an attorney. You can focus on being the litigator inside the courtroom, and we focus on everything else. The best example I've heard of this is a meteorologist. They are the ones displaying everything. They're the ones going through everything for the county, for the city, the state, whatever it may be, and explaining what the weather's going to happen. There's another person in a booth somewhere where you have no clue where they are who's operating that big green screen behind them. The meteorologist needs to trust that person in the booth. We are that person in the booth. The trial technician is the person making sure your presentation runs smoothly, but not only smoothly, everything is exactly the way it needs to be. The documents are redacted. The documents are Bates numbered. The documents are in the correct order. The documents are the ones that you planned on using with the witness itself. Your deposition is edited. The exhibits are linked with the deposition. Whatever it may be, it is the trial technician's responsibility to make sure that your presentation runs as smoothly as possible. They have the experience, for one. All of our trial technicians here have about 25 cases per year, all across the country. They are experts in multiple platforms, OnCue, PowerPoint, like we've mentioned, DICOM viewers, like I keep saying over and over again, all the interactives that we build. They allow you to focus on being an attorney. We worry about the equipment. We worry about the software. We work with IT to make sure it runs well. We do all of the troubleshooting, like the resolution issue that Jerrod mentioned. We go in and help fix it. We go in and make sure it's a seamless presentation because we're working with you from beginning to end. Your trial technician is going to be there with you in the morning, afternoon, night, weekend, whenever it may be, to help you working on the outlines, to help you work on what's going to be displayed, any new designs that you may need. They'll work with both our graphics team here at TrialQuest, or they'll help build some of these graphics with you on site and in the courtroom to make sure it's a last minute request and it's met. Apart from that, they assist with your witness preparation and your war room support in there, working with them to make sure they're comfortable, working till 2 a.m. with a radiologist to make sure he understands what needs to be displayed and how they need to display it to work on their presentation themselves. Just a few things that they do cover. I think I've mentioned a lot of these. The document management, making sure everything's brought in, it's converted to the appropriate format. Everything's in the database. You're not going to go up there and say, pull up the page 1900. We type in 1900, it's not there. It's their responsibility to make sure the database is correct. All the files are converted. All your documents are OCR'd or text recognition, and they're redacted. So we can do some searches if we need to, but we can make sure that all the information that cannot be displayed is already gone. Insurance, social security numbers, date of birth, etc. Going through those Bates numbers, working with the court system that they need to have a specific sticker, a color sticker, what needs to be on the sticker, where it needs to be placed. We make sure that that's either digitally completed or physically completed with you to make sure all your exhibits are appropriately managed within the database, going through the deposition preparation, making the clips, making impeachment clips, exporting for the court. They need providing the court reporter a TXT or an ASCII format so they can put it inside the record and save them a lot of typing for one day, or any video editing, surveillance videos like Jerrod went through. And then, like I mentioned, the war room support itself, going in, working with you, helping supply some of the equipment that you may need, monitors, printers, cabling, projectors, whatever it is inside the war room, so you can do tests. You can do your dry runs with your experts the night before, exactly how you plan to present it in court the next day.
Yeah, and I think those are all good points where, a lot of our clients are smaller firms. They might be doing some of the presentation work themselves. Maybe somebody's in-house that's a little more tech savvy. So, I think understanding all the things that are available is a great starting point, because many times we kind of do the same thing over and over again. It's either comfortable or it's been successful in the past, so we think about, okay, I'm replicating an Elmo with a trial tech, right? They can, make sure my documents come up, my paralegal can pull up an Adobe PDF or something. As we look at that and as you're preparing, you need to look at the different options and see when cases have a nuance that they need a little bit more. So having your checklist and kind of being prepared are really important. And so we kind of look at this as we get near the end of this webinar here today. Is one of the big takeaway is as we look at successful trials and outcomes, a lot of it comes from a start to finish view of the case as early as possible, right? So many times we get a call from a client 2 weeks before trial. Hey, I need a timeline. Hey, I need help with opening. I need a trial tech. That's great. Those things are kind of the everyday, but it really starts with the attorneys and the trial teams themselves, viewing their case as, how am I going to tell this story to the judge and to the jury? And doing that early on sets the table for all the things that come later. You might not actually create graphics till a later point in time, but you have to start thinking about your storyline, your theme development, strategically, how is that going to come together? I hear it all the time when we do mock trials. A lot of the trial teams are like, well, this really helped me view my case as being, how is the trial going to go? And we're still a year before the trial. So I have time to work with my experts and other witnesses to kind of, tell the storyline a little bit better. So, we have to think about it in this kind of holistic view of all these different elements. It doesn't mean you need every single one of them, but you need to start thinking about it and preparing in a way that when you do end up going to trial, you've kind of addressed those issues, you're prepared, because time is the enemy, right? Like that's our biggest enemy in this legal world is you don't have enough time to really, develop your message earlier on, and then using the tools that are kind of helping with that. So as early as you can get to it, the way you can kind of view your case and then looking at the different tools that are available really sets the table for a successful outcome in a trial.
And how do we prepare for this seamless presentation? What do we do to make sure all of our check boxes are checked? Are we building a tech-ready trial team? Whose roles and responsibilities? Who does what? What is the trial technician going to assist with? What's the medical team going to assist with? Who needs to handle what? Who's going to have the backup plans? Who's going to develop these backup plans? Who's going to get lunch that day? Who is going to handle what we need to handle for that well before we even step foot into a courtroom? There's checklists, obviously, that we just mentioned. What hardware and software do you need to test? Do you have Zoom witnesses? Who's going to test the internet connection with the Zoom the day before, the day of? Is the court going to provide the link to everyone? What's the backup plan if this Zoom fails? What's the backup plan if your projector catches on fire, which has happened to me in Cleveland, Ohio, and I had nightmares about it every single day? What do you do if that does happen? Who's going to do all of these things and take these steps to make sure that everyone's prepared? And the jurors don't really see any of the issues, don't really see anything because you had redundancy and you had backup plans.
Yeah. Yeah, and I think that kind of leads into, really what is the takeaway for 2026, right? And obviously, this is not a full jury presentation on how do we, deliver the message, what are issues in our cases, that's a different presentation. But what's the takeaway here? And it's really being more prepared, evaluating your cases as early as possible, and starting to develop what you're going to present, how you're going to present it. It's not always that you're going to use the latest tool, the most, technological elements. Old school is still in, but it's not really even a battle of old versus new techniques. It's really being in a way that you can teach your case. You can use those tutorials. You can deliver a message that gives a simple answer, as simple as possible, to jurors. And so, when we look at this, be it you're handling all of the presentation work yourself, you're a solo or have, limited staff, you're a larger firm and you have some lit support people, or you're working with a vendor like us or someone similar, you really just need to be thinking about kind of this checklist is, how are you going to get these things done? When are they due? One of the things that, of these bullet points is kind of exhibit deadlines. This is a big one where when we work with a client, I think this comes up often. They say, hey, my exhibits are due on this date. Well, did the judge clarify that's your evidence exhibits and you're exchanging documents, or is that your demonstratives? And so, things as little as that can make a big difference in your preparation timeline, giving you a little more time to develop your exhibits and put them together right before trial. And so even just clarifying and making sure you have your exhibit exchange deadlines and demonstratives. And I have judges all over the place with different deadlines, 90 days pretrial conference day, show it before you use it, day of court for demonstratives. So, all these things have to be taken into account in today's world because you really want to be more prepared. You want to have a good, clear message that you can reiterate over and over in trial, and have a plan for when things don't work well. If some technical issues, who's going to handle what items. So your trial team, either internally or working with a vendor, you're all on the same page and you have a plan on how to best present that case.
Right. I think with that.
All right. Well, hopefully we were able to provide something of use for you today. We always want to have something that you walk away with that's helpful. And I see there's a couple questions in the chat, so we'll answer a couple quick ones. If we don't get to all the questions, we will definitely review them and try to get a follow-up with you and answer those questions as needed. So feel free to, if you have some questions that you pop in the chat, if we don't quite get to them, we'll do a follow-up and get those answers for you. Or if you need some advice or tips on anything that maybe we didn't cover enough today in this shorter presentation. So the first one I see, and this is a pretty common question. I'll take this first one, Kevin. How long does it normally take to develop a presentation, the length of time? Not just a single graphic, like a timeline, but more of like the presentation itself. Well, my answer is always as early as possible, right? Like how much time do you have? How soon can you do it? Because really preparation starts with organizing the information, putting things together before you actually put pen to paper on the sense of building demonstratives and PowerPoint decks and, those kind of tutorial items. Typically working on a more standard case, we're probably looking at 2-ish weeks. Not that you're going to need all 80 hours of billable time to put together a lot of these presentations. Some of them could be more complex. It might be more like 3 or 4 weeks if you're having animation elements, interactivity. And you always want to move backwards based on demonstrative exchanges. So, we might be able to do everything within 2 weeks before trial. But if you have to exchange things a week before trial, we really need to be before that. So I highly encourage that if you're thinking about doing something, contact your vendor or work internally as a team and put a plan in place, have a conversation, get some ideas together, get pricing together, and then that can kind of help you with production scheduling. But I would say in a general sense, 2-ish weeks is usually pretty common for developing a kind of a presentation and opening and whatnot. And a lot of that's limited by when our clients are ready to actually focus on it. You have a lot of things on your plate, a lot of other cases that need attention too. So, we're realistic in that. And so you can put them together much quicker, but I'd say 2-ish weeks if you can.
I've got one here. When do I need to get a trial technician involved? So that's kind of a loaded question. So there's a few different ways a trial technician can get involved, whether it be a single day playback of just a deposition. Give us a few days notice. Get us 2 to 3 days notice, just so we can make sure we have a technician locally to you. Or if we don't, how do we get one to you? That way we can give you a good quote, good pricing, figure it all out with you, work out the deposition, work out any edits you may want to actually have made, and then get it over. Full length trials, let's say a week to 3 week trials, things like that. Give us as much notice as possible, as Jerrod mentioned before, but at least 2 weeks. Give us at least 2 weeks notice so we can, again, reserve that trial technician for you, find local support if we can, get someone to you, make sure we can judge what equipment you need inside the courthouse, work on all your documents, work on all your other items that we need to prepare the database. But the more time you give us, the more time we'll have, for one, with you to work out what strategies, things you may have, and help identify any demonstratives that you may want to create outside of just displaying some records. Simple, I'll say, car wreck cases are pretty non-involved for us. I use that specifically for that word. But if it's just a ran in the back of somebody, we need to show a couple documents, maybe show a couple videos, whatever it may be, great. But do you need an overhead map? Do you need to have some DICOM shown with your experts? Do you need to have some depositions edited? Do you need to have some impeachment clips ready? Even if it's just a text transcript, what do we need to do to make sure that everything within your outlines that you're planning to present are ready for you? So just to kind of recap that, playbacks give us 2 to 3 days. Trial technicians, at least 2 weeks. We can make sure you're on the schedule and we're ready to go.
Yeah, I think that's kind of goes. That's a good answer, but it kind of goes to the theme of the whole webinar today. Is the earlier you think about it and at least get a plan in place, it doesn't mean that you're incurring a bunch of cost or whatnot, but you're putting kind of the steps in place to have a successful presentation if it goes forward, right? So having an earlier talk about, hey, put me on your schedule. This is what I think we're going to do. Let's talk about some of the elements. Are your documents Bates numbered? I mean, that's one of the huge things that when we work with clients is, they're, oh, my documents are Bates numbered. And then you look at them and there's like inconsistent numbering. It's not the way the court wanted them formatted. So, and you want those documents organized and numbered as early as possible so you can be making your outlines for opening and witnesses and things off of your trial Bates numbers. So, just little things like that. I think it's just really important in today's environment that we get kind of the ball rolling sooner. Doesn't always mean it's going to incur you a cost sooner. And I think that's always a kind of in the old school way is like, hey, I don't, my case may settle. I don't want to spend any money. You don't always have to spend money, but you do want to get your planning in place and kind of set the table, get your schedules up. If you're doing it internally, do you have all the resources you need, or do you have time to bring somebody in to help you if it's not coming together? So, I think that's the big takeaway. And kind of with that, we're going to wrap up. And, hopefully we didn't take up too much of anybody's time today. Hopefully you learned something new. Always reach out if you have a question. But hopefully you have a successful trial year. Some of you probably success is avoiding the courtroom, so making sure you're doing the presentations to judges and mediations to get good results for your client. And with that, we thank you for your time today.
Thank you.
Thank you.